Hi, everybody. This is Alan Hollander, the CEO of ePractice Manager. I want to welcome back somebody who has done some webinars for us previously. Very, very well received. Timothy Bowles, Esquire. Tim is a frequent employment law blogger. He is the author of the Bowles Law Report, which is a publication that goes to over 20,000 recipients. He is a true expert on workplace-related subjects, discrimination, harassment, employee pay practices, HR, and more. We're delighted to have him here today so he can talk about these new and important changes for 2021 that may very well affect your dental practices. So Tim, over to you.
Hey, thank you, Alan. And it's a pleasure to be here this afternoon with all of you. Welcome. I'm excited to be outlining for you kind of a mid-year report here as we open up more and more post-pandemic. And we have a lot to cover over the next half hour or so. I want to start with an outline, but first understand that, as Alan said, we have practiced employment law on behalf of management and many, many healthcare clients for some decades now. And we understand the challenges that you face with personnel, with the changing regulations and so forth. And this, I hope, will be an enabler, if you will, to a greater expansion and greater and more efficient operation. And if I've helped in that regard over this period of time, then I've done my job. So again, welcome. I'm speaking to you from my cave still here in home office in Pasadena, California. We're going to be covering mainly the national scene and the national trends. I'm going to speak to some degree to California law as a comparison or as an example of what we are all facing as managers and personnel directors. But as I say, largely an emphasis on what this new administration is looking at, the kinds of policy making that they've indicated it's in the wind and it's already been in place. So let's just get started here. The three main areas we're going to cover, and maybe many of you are tired of hearing of it, but COVID and pandemic related matters continue to dominate the spotlight. Even today, we'll be talking about vaccination mandatory and voluntary, but even today, just two items in the New York Times on just how volatile and active this particular issue is. Here's one quite relevant to most of our listeners here as healthcare practitioners. And this says 153 Texas hospital workers are fired or resign over mandatory vaccine policy. Here's another one. This is from, again, today's paper. Morgan Stanley says no vaccine, no entry. So here's an entity that is requiring vaccination, not just for their staff, but also their public in order to actually physically enter their premises. These are, again, ongoing topics. And the reason that we want to discuss that today is the fact that the law is not settled on this. There is a judgment call to be made here, depending, of course, on what your local ultimate authority is saying about requirements for pandemic protection for your particular practice. The federal law in this area can only suggest, by and large, and guide. The state laws and the local laws are by and large, the ultimate decider. So we'll cover that. As also stated here, the area of discrimination, this is EEOC, is the Equal Opportunity, Equal Employment Opportunity Commission, federal agency, and they are in charge of not promulgating, but promoting and also enforcing the anti-discrimination workplace laws that exist on the federal level. And I mentioned gender equality here because this has been the one area since the inauguration where the federal government, the EEOC, has actually issued guidances and emphasis on this particular kind of workplace discrimination. So we'll be covering that later in this period. And then finally, I wanted to touch on the area of wages, the area of compensation in the workplace. And this, again, as I said, is by and large the federal government setting the policy priorities, and we'll be talking about this as well in the wind. But there isn't any law that I know of that has come down in the last 6 months on the area of wages and compensation that any of us need to be immediately concerned about on the federal level. And this is a link to a news release from the Department of Labor outlining these administrative priorities for the coming months in summer of this year. I should also say this, we're going to be going through about 30 slides here. I guess that's about one a minute. But at the end, I'm going to give you our contact information and invite you all to email us for a PDF of these slides so that you'll have all this material, hard copy or soft copy, email attachment rather, so that you'll have the benefit of what we're presenting here. And in terms of the policy on the workplace, there are two main plans that have been issued by the Biden administration, and they include the Return to Work plan, as it's stated here, issued about 5-6 weeks ago, and the America Families Plan, issued a week or two before that. I've put in parentheses the areas of those plans that relate most immediately to the workplace. And again, these are policy prerogatives and policy priorities of the new administration. None of this is set in stone or law yet, but they include a drive to increase child care funding, personal tax credits for care expenses, promoting tax credits for retaining employees, streamlining and expanding unemployment benefits, and also expanded paid leave for illness, pregnancy, newborn care, and a national paid sick leave initiative for up to 7 days of paid sick leave. And I think you get the flavor. These are all stemming from our shared experience over the past year plus, when a good number of our workforce was out, laid off, on furlough, and so forth. Anyway, so these are the priorities that the administration is setting. And we'll now go to the main topic of today, which is vaccination relative to COVID-19. The issue is whether or not an employer should be requiring that, or whether it should be a voluntary process. Here's a California example. We, on the 15th of June, had a new set of standards, actually the rolling back or the rescission, the cancellation of the restrictions that had been placed on business and on life in general, public life in general here. And that included the rollback of any required masking by those that have been vaccinated. There are 3 exceptions in our state. And as it says here on the screen, local health laws are also quite relevant, because in our state, as well as any other, a county or municipal city ordinance can not supersede the state, but can exceed the standards of the state and make things even more restrictive than perhaps the state is dictating. Here, the standard after the 15th of June, as I said, is no masking for those that have been vaccinated. But there's an exception to that, 3 exceptions, very important, one of which is healthcare facilities. So even vaccinated folks who are visiting or on staff at a dental office, for example, in our state, have to be masked still. And I was just at my local dentist yesterday, and everyone was masked who was working there. So again, these are a changing picture here, but your office should be considering whether or not, unless mandatory is being dictated by the state, and I know of no state that's doing that, whether or not you're going to be mandatory or voluntary. Now, again, this is a reference that you can gain from our materials if you get them after this event. But I'm referencing now to the FAQs, frequently asked questions, of the American Dental Association, last updated in February. And I'm only giving you several examples here, things to think about, and well beyond the scope of what I'm going to be speaking about today. We're going to be touching on the high points or the low points, but not every detail. These are just 3 questions within this issuance by the ADA. Can a dental practice require me to get a vaccine? I will answer that one here shortly. What if I refuse to be vaccinated for personal reasons? That's answered in this circular. We'll talk about that as well today. If I get the vaccine, can I stop wearing a mask and social distancing? Well, I've attempted to already answer that question. It depends on the state and local authorities. They're the ultimate word, as I said. So first question, which is, this again is from the fact and answer, a question and answer circular of the ADA. Can I, as a healthcare employer, require my employees to get a vaccine? You can see this answer, probably written by a lawyer, is likely yes, at least as to staff with direct patient contact. And you know, if your state, your local is requiring that for a healthcare facility, there's really no contemplating whether or not to do it. It's going to be required under the law. Now, this raises, however, legal questions, which we're going to get into here, and some practical challenges. And this is right down the line of what we do every day here in my office as an employer side employment lawyer, dealing with how you have to ask these questions and how you have to handle inquiries. The EEOC, as I said, is in charge of enforcing the anti-discrimination law in the nation. And this includes guidelines on the balance between what an employer can ask or should and must ask to protect the public that are coming into that workplace, as well as the staff. And on the other side would be the privacy interests of public or staff, which are perhaps in some instances outweigh the right of us as employers to know. So this again is in a circular that you can find, and we're giving you the references to under the EEOC. Last updated just a month ago, a little less than a month ago. They started in March of last year to roll back many of the privacy considerations and to enable us to ask more questions and to be more intrusive. And that includes sending symptomatic workers home, permitted to take temperatures every day, requiring testing to enter the workplace. And they also, of course, as I do, would urge you all, if you don't already have an overall screening plan. I imagine you have that after all this time. Now, can we ask whether a worker has been vaccinated? Absolutely. And the technical on that is it's not a health inquiry. It's not a private health matter to know whether or not someone's received the vaccination as an employee of yours. Now, if they say no, they haven't been, that's when their alarm bells can need to go off in terms of what you ask the question, what next question would you ask? The inquiry, as it says, it has to be job related, and it can't be beyond job or business necessity. And we'll get into that in a minute. I'm gonna, as I say here, we have to limit our questions to job related questions. Now, how does that roll out? The main consideration in terms of questions you can't ask are questions that are designed to bring out of the answering employee whether or not they have what we term a disability, a mental or physical condition, personal condition that that cannot be discriminated against. Now, part of the law is you can't even ask to see whether or not somebody has a condition. That's actually considered by the EOC to be improper. Another one is genetic characteristics. These are inherited characteristics that might make someone more prone to a disease or an illness. And religious belief is the other cautionary one. You can't ask, do you have a belief? If they say no, is this because of your religion? You can't ask that. But as it says here, an okay screening question is there any reason that would prevent you? If somebody says no, well, are you intending, or is there any reason to prevent you? Now, the key is you could ask that question and they say, yes, there is. It's because of my belief, my religious belief against vaccination, Christian Science for perhaps example. It's because I have a physical condition that's prone to greater side effects, for example. You asked a general question, they gave you back a specific answer. Now, that then means all you need to do at that point, they've opened up the consideration of the problem. Now we're going to discuss that and find out whether it can be worked out. It's funny because in a mandatory program in which one sends the individual worker to an outside third party for the inoculation, we're actually beyond the requirement of asking the uncomfortable questions, perhaps uncomfortable. That's going to be up to the pharmacy or the hospital that's taking care of all that. It's beyond our duty, or I guess even our right to know. But let's say they come back, they've been asked the questions, they say they can't get a vaccine, and now they're standing in front of us, and it does come out that they have either a religious objection or a disability objection to the process. Now, as it says here, and I've underlined it, our duty is to seek a reasonable accommodation to that individual short of what we call undue hardship. Now, in this conversation, we know they have a disability, that we perhaps know that they have a religious practice protocol that prevents that from receiving it. Can we accommodate that? Now, that's the conversation. We have the duty to seek out a reasonable accommodation. It is perhaps even probable that we cannot, if there's a physical condition that prevents someone from, at the risk of higher side effects, from getting it. But at least we have to explore it. And what is the, as we go along with that, of course, if they give us medical information, that has to be kept confidential. And it's excluding the unvaccinated worker as a last resort, as it becomes impossible to have that person exist in our practice while they're unvaccinated. Then it's at that point that we would be able to exclude them. All I can say is at that point, I would recommend very strongly that you have legal counsel to guide you through that process, because If it isn't written, it isn't true. We want to document carefully if we're going to let somebody outside until perhaps conditions or even more free to have people in the office. But the ultimate, perhaps, reasonable accommodation would be, can existing protocols for masking and social distancing be maintained in order to accommodate that person? Again, this is not an easy question to answer, because if social distancing is no longer required among people that are vaccinated, what are we going to do? We're going to have the one guy who doesn't want to be vaccinated stay 6 feet apart from everybody else. It may not be workable. So again, it's a case-by-case process. Voluntary vaccination would be the caution here, which is similar and parallel to the one we've just covered, is that if we have a pre-screening process for whether somebody is being offered a vaccination, we don't want to be asking, is there any reason that you wouldn't want to have a voluntary vaccination? Or do you have a religious belief that would prevent it? Or do you have a disability? Don't ask those questions. You can ask the question, would there be any reason to prevent you from having that? And going from there. But if it's voluntary and they say no, they don't want it, I question whether or not you want to ask why. It's just a no. Now, one of the areas of voluntary vaccination practice, of course, is these incentives. California has a lottery now. Somebody can win $1 million if they're vaccinated. They've chosen to be vaccinated. And we also have these in the workplace. So the issue here is, if you're going to give an incentive, it can't be so extreme that it seems like someone's being punished for not getting a shot, or it might signal, if it's a large incentive, to our belief, whether it's perceived or actual or not, that vaccinations are risky. And published examples paid time off to get vaccinations, inoculations, some small cash bonus, even a bottle of water was suggested. I'm not suggesting that. It's a little bit petty. All right. Now, and if we're voluntary, we can promote recommendations of state, local, federal. We can provide factual information, logistical information, make it available on site. We can pay for the vaccinations. We can pay time off or unpaid time off from the process. And I wanted to cite to you here, many of you probably are aware of this, but within the past month or so, the ADA has published the ethics of vaccination by a number of thinkers and experts on the area of ethics. And there are 10 recommendations. Again, I'm only covering highlights here, but this particular white paper does suggest that we need to consider how to deal with our staff who can't be vaccinated, choose not to be, and they're at the same time ensures health and safety of other staff and patients. That the dentist and staff should agree on how to handle the patient inquiry about whether the staff and the dentist have been vaccinated. That's a chance to discuss the steps the office would take to keep patients safe. And the white paper goes through various considerations there. Now, policy, this is essential. It seems to me that if you're going to have, whether it's a policy of vaccination mandatory or voluntary, you're going to have a policy. And if you write to us in the follow-up and ask for our templates, we're happy to give you what we've developed over the past several months for our workers, for our employer clients. I would only say this, that we're in California and this is our state of practice. And if you're in another state, that's fine. You're welcome to our template. But if you are in another state, you want to consult with local counsel there to see whether or not there's something even greater or whether or not it's acceptable under the local and applicable laws. But here are some of the areas of consideration. Exemptions, as we've been discussing, risks, incentives for the voluntary program, um, and no discrimination or retaliation for someone who is refused. Now, of course, you've probably noticed I left off the real question that might come up with your practice is: person doesn't have a religious objection, doesn't have a disability objection under which they are protected by the law and what the EEOC has published. They simply are against it by principle. Maybe they have a political reason for it. Maybe they have some their own personal values objection. And I'm going to say that person is not protected by any specific law that I'm aware of, but are they protected by the practical considerations of your simply not just rejecting their protest out of hand? We have to look at how even that can be accommodated, even though they have no, quote, legal right to that because of the fallout that might occur. And again, case by case, let's consult with our counsel. We're happy to talk to any of you about that, even if you're in another state, although again, we're going to caution you that the ultimate answer would have to be side-checked by your local counsel if you're not in California. Now, let's go to this other area that the federal government is emphasizing, and that's discrimination. We know that I'm assuming we know, we've heard of this term at will. In most states, it is presumed that a relationship between an employer and a worker is at will employment, which means that it's free form. A relationship can be ended at any time by either side, either party, with or without notice, and with or without a reason. And of course, that leads us to the question, well, if we have an at will situation, we don't need a reason, or we can fire somebody for any reason, aren't we protected, for letting somebody go for a reason that we find compelling? They don't want to get vaccinated, for example, and they're not protected. Or they're protected under, are there any reasons that we'd be given pause to let somebody go simply on this premise? And the answer to that is yes. In Los Angeles County, where we do a lot of our practice, there are approximately 30% of the cases in our county that are employment related. So this is a tremendous area of controversy as a general proposition. And we ask, why is it so prevalent? Well, the reason started in 1964 with the reasons that are illegal to let somebody go. And these are so-called protected classifications. There originally were 5 of them under the Federal Civil Rights Act of 1964, and that's shorthand by us lawyers. We call it Title VII because it was Title VII of a particular law. Again, the EEOC covers enforcing this law nationwide. And now what we have, I should say this, the basic criteria of this law include that all private employers with 15 or more on their payroll are covered by this federal law. If you have less on your payroll, you need to be aware that the state laws against discrimination, by and large, will have a lesser threshold of coverage. In California, it's 5 or more on payroll, by which the similar law against discrimination apply, similar laws apply. And in other states, there are other numbers, less or greater than 5. Some of them equal to 15. So you just have to be aware of what the state law might dictate as well. It not only protects employees, but also job applicants and former employees against discrimination. And it also protects regardless of whether a person is a citizen or even is in status as an immigrant in our country. Now, as I say, why are 30% of the cases in California and LA County employment related? This is because the number of protected classifications has grown since 1964 to, I think it's last count of about 18. And I've mentioned them here on the screen. This mentions the California parallel law. The federal law has also expanded to disability, for example, age discrimination, and many other things. Now, interestingly enough, this is California, but you can see here that it includes sex, and then separately, gender and gender identity and gender expression. So this is your cross-dresser, your transgender person, sexual orientation, same-sex, as an item of non-discrimination in California. And what's interesting to understand here is that these are separate in California. Sex, pregnancy, childbirth, and so forth, gender, and sexual orientation are separate. The federal law changed about a year ago to include all of those characteristics within the concept of discrimination prohibition for that person's gender. So sexual identity, sexual orientation are now under this pretty remarkable Supreme Court decision by Judge Gorsuch, who is not a liberal on the court. He's a conservative. He was joined by 5 others to say that the definition of sex for discrimination purposes includes these other concepts that relate to a person's gender. So what the Biden administration has done since then is they've continued to emphasize the prohibition against sexual orientation and identity, gender identity, so-called SOGI, S-O-G-I, sexual orientation and gender identity discrimination. And so we need to be aware that if it comes to our attention, whether it's an applicant, whether it's an employee, that if a person has and holds a certain orientation that's in the minority, or male, female, there are discriminations against men and women, of course, that we make our job decisions based on merit, based on qualification, based on competence. Fortunately, incompetence, the inability to do a job, is not a protected classification. I remember a Saturday Night Live skit that made fun of that. But there is every right, again, for us to regulate the workplace on the basis of competence, but not on the basis of these protected classes, including, as I've said, SOGI. So the takeaway with that is keep the conversation on qualification and performance. As always, this is not new law. This is just simply the federal government emphasizing this particular area of discrimination. And when I say keep the conversation related to performance, I'm talking about documentation. I'm talking about that employee who might see the writing on the wall in terms of perhaps they're on the block to be let go because they're messing up. And all of a sudden they raise, hey, I'm pregnant, or hey, I'm gay, or I'm this, or I'm that. And then you have an alarm bell go off, which is, I'm letting this person go, but I've just put it on notice that they're part of a protected class. That should give you caution to make sure that the decision that you actually make is going to be based on that performance. And hopefully, and we do this week by week, we counsel employers to be very systematic about how they interact with that employee as they head them toward the door. And again, it's beyond the scope of this, but in many cases, that's a situation where the lightest touch, not untruthful and not holding back, but a firm and truthful conversation is taking place that ends with a transition, giving that person perhaps some severance pay in exchange for a release document in which they promise, in exchange for that extra money, to not come back against us as an employer. So again, this is just 2021 now, that this entire area of sexual discrimination, including orientation and identity, is the hot topic in discrimination. Now, I mentioned at the earlier part that the DOL, Department of Labor, federal agency, has issued this memo. The link was previously shown on another screen, in which they have set a regulatory agenda for this summer. And none of this has an immediate impact on our practices because most of these deal with federal contractors. I suppose it's possible the dental office is a federal contractor and you would have some of this in the wind, $15 an hour minimum wage for all workers, Davis-Bacon and related acts, that's your prevailing wage law for localities in which contracts with federal agencies for services or construction, for example, has to be in keeping in minimal levels set in each locality, and tightening independent contractor rules. That might have its immediate effect or a soon to be developed effect in private workplaces that are not federally related, but we'll just keep our eye on that. Very good. Okay, so takeaways. Constant change. This is why we're in practice. This is why we consult with our clients all the time and new inquiries all the time, because particularly in our age of COVID, these regulations, these workplace laws are changing all the time, and we need to be in close attention to that. And as it says, written policy. If it isn't written, it isn't true. Handshakes and good guy conversations rarely succeed if there's a falling out, and then memories will differ on how things were developed with someone who was let go. And as I say, we have this is our practice. This is all we do. So I think many of you have already opted in for our e-letter. This is a weekly update on changing law, not just in California, but federally. We invite you to reach out to us for that. And as I say, the template vaccination policies that any of those will provide at your request with no charge. It says in progress, but we've actually developed a template for that vaccination. And then opt in for our flat rate fees. We have model workplace policy manual and a whole supplement on COVID for 2021 that's available to you all. This is our contact information. Amy Rosales, office mgr@tbowleslaw.com, does a marvelous job in fielding any of your inquiries and getting them and swiftly answered into the right person to help you. Phone number, etc. We have 3 lawyers in my office, including myself, Cindy Bamforth, and Helena Coburn. And by the way, I should mention that Helena is also licensed to practice in Florida. So any of you that are there, reach out to us if you have any questions. She can. We don't have to give you another referral in that state to answer the questions. Now, I understand that there might have been some questions posed prior to this close here, and Gillian, if you want to give me a shout out on any of these, let's see if I do my best to answer them before we end off.
Yeah, great. We have a couple questions that came in. The first is on handouts. I know you covered this a little bit, you touched on it, but she might have missed it. And the last webinar, just for our attendees, what happened in the last webinar was we turned this presentation that Tim created into a PowerPoint, which will be available after the close of the webinar, probably by tomorrow. Everybody who attended can get that along with Tim's contact information, but additional handouts, Tim, if you want to touch on that. I know your contact info is up on the screen, but any handouts that you might have, for the attendees on the things that you went over?
Right. I've already mentioned the vaccination template, which is uh, it covers both mandatory and voluntary. So that's certainly available, and you've covered the rest.
Okay, great. The next is, do you have anything, you went over gender identity and a lot of that. And what about touching on pronouns?
Oh,
Anything that you have on that would be
yeah.
great.
Thank you. That's actually in the wind. There's in California we have I think it goes into effect in a year or two, where policy has to actually recognize the spectrum, folks that refer to them, individuals who refer to themselves as they. It wouldn't be a bad idea to get uh, familiar with that. I don't know of any state that's actually imposed that yet in terms of a quote requirement, end quote. It's just a good idea to be sensitive to that, so that if somebody wants to be called something other than he or she, for heaven's sakes, that's a reasonable accommodation. That's not a hard thing. It's not going to cost you anything more to respect that person's wishes.
Great. And then I have one more here that just came in. If our office is still working from home, do we need to have a vaccine policy?
Again, that depends, and I assume that was not a dental office. That would be a challenge. But no, there's no vaccination policy required. There's only in instances such as the Morgan Stanley that I mentioned, where they've decided to be mandatory. This hospital has decided to be mandatory and has fired folks that don't want to play. That, by the way, this is not on topic, but I'll just mention this while I'm thinking of it. The protesting employees in that case, for our healthcare practitioning listeners, the protesters filed suit against this hospital in Houston, and that suit was shot down and dismissed by the judge there. Based on the fact that they were saying it's an experimental process, and the judge pointed out that it had been through trials and they were not guinea pigs, that this was beyond that stage. Because that case was dismissed on their behalf, I venture whether or not those folks that were not hired, or I'm sorry, if they were fired as a result of their resistance, are going to have much of a ground to challenge it now. But to answer your question, no, if we're socially distanced and no one's interacting, whether they're vaccinated or not, it's kind of a moot point as to whether or not to have a vaccination policy. Is it a good idea otherwise, even without continuing work in a physical office? I think it is, because, well, if it isn't written, it isn't true. I've said that a couple of times here. Hope that answers the question.
Okay, great. Yeah, that wraps up all of the questions that came in.
Very good. Very good. So everyone, be safe, be practical, be productive, serve all your public well as your workforce. And it's been a pleasure and an honor to be able to spend time with you here. And I look forward to working with all of you again. And again, we'll be happy to field any of your questions, provide the free material, and also available to help you, as mentioned, in exchange for our fees and our flat rates. So again, thank you very much. Have a great rest of the day.
Tim, wonderful talk. Thank you very much. Great to have you here, and I really look forward to more. To our listeners, if there's material about which you would like to learn more, any area about your practice or other subject matter, whether it involves the legal side, the accounting side, or any practice management topics, please let us know. And we're happy to put together information and do future webinars on these. We love to get your feedback. So thank you very much for listening. Go to our website at ePracticeManager.com. You can schedule a free consultation on any particular subject, anything that you'd like to talk about in your practice. We're happy to do it. Just go to our calendar. You can pick a time that works for you, and we'll be delighted to really dive in to whatever issues you care to discuss. Thank you all very much for attending. Take care.